All right, ladies and gentlemen, welcome back. We have lots to discuss. A big week at the U.S. Supreme Court, and some very interesting cases to talk about. And joining us to do just that is our friend Paul Callan, CNN legal analyst, former New York City homicide prosecutor, criminal defense attorney. Like I said, it's a very big business card he has. Welcome, Paul. Good to see you as always.
Always nice being with you, Steve.
Thank you very much. All right, let's talk about first. I think this was on Monday. The Supreme Court heard arguments and appeared to be skeptical over the NLRB recess, quote-unquote recess appointments that were made by Barack Obama back in 2012. The Senate, technically, according to Republicans at least, was still in session, and they did it to make sure that Obama couldn't appoint anybody, and he went and appointed them anyway. And it looks like the justices appeared to struggle with how far to go, but they also appeared to have a problem with what Obama did.
Yeah, a lot of the justices seem to have skepticism about it, and it wasn't just people who are normally thought to be the conservatives on the court. A lot of the justices asked hard questions here. You know, this provision about interim appointments came into the Constitution back at a time when people traveled by horseback, and Congress was out of session for very long periods of time. So the Founding Fathers built in this provision that the President could act when Congress was adjourned or in recess. And of course, in modern days, these recesses are very short. And so the Obama administration took advantage of a very brief adjournment or recess, depending upon what kind of word you want to use to apply to it, to slip in NLRB appointees who were being blocked by the Senate. And it's a very important precedent, and I have to say it doesn't just apply to the Obama administration. President Bush, Republican presidents have done the same thing. It's sort of the modern age being used to amend the Constitution so that presidents can get around the power of Congress.
Yeah, and you know, when Justice Stephen Breyer says that the Founding Fathers didn't intend the recess power to be, just as you described, a tool to help the president avoid Senate approval for appointments, it makes you think. Of course, predicting here is a fool's game, but it makes you think that the court will rule against Obama in one way or another.
Yes, I think and it's always hard, to predict these things based on the questioning that goes on during oral argument, because a lot of times the justices just like to sort of test the lawyers and ask them tough questions and see how they handle the questions. But the movement of the questioning here seemed to indicate a skepticism by the court about this tampering with the Constitution. I mean, it really was put into place by the Founding Fathers, to deal with a situation when Congress just wasn't available and couldn't weigh in on an issue, so they had this special exception. And, when Congress is closed for 3 or 4 days or a week, that doesn't sound like the situation the Founding Fathers had in mind.
And it's going to be interesting if they do overturn these appointments. I'm not familiar right now with whether or not they've ruled on issues. I think they have, and be interesting to see if that garners another legal challenge to the rulings they might have made if these people have to be removed after this ruling, and whether or not they'd still be valid.
Well, that's a really interesting question, and constitutional scholars are looking at it and saying, the court, they probably could come up with some way to allow those rulings to remain in place, but they could also say, hey, those are totally invalid rulings, and then what happens? You upset that apple cart, and there are a lot of individual cases that were decided as a result of rulings handed down by those NLRB appointees. It could spawn a whole bunch of litigation across the country.
Very interesting. Yep. We're talking to our friend Paul Callan, CNN legal analyst, here on the Steve Malzberg Show. 2 other Supreme Court cases, and they're really important here. And one is the Castleman case, and this involves a federal gun ban. Federal law bars a person convicted of a misdemeanor domestic violence charge involving physical force or deadly weapon from possessing a firearm. So you have this guy here, James Castleman. He pleaded guilty to a misdemeanor domestic assault charge in 2001 back in Tennessee. And then in 2009, he was caught with a gun, and he was charged with illegal possession of a firearm after he and his wife were accused of buying guns and selling them on the black market. But that aside, the court now, and correct me if I'm wrong, what's before the court is you know, what constitutes, how far is enough? In other words, if you touch somebody, a woman, if a husband or a boyfriend touches a woman, and that's construed as misdemeanor assault, should he then be barred from owning a gun for the rest of his life? Or should the crime, if you will, be more severe? And this is what the justices are going to try to decide, I guess.
Yeah, they had a real tough argument going on in this case because, you know, this federal law was enacted so that individuals who engage in acts of domestic violence against their partners, and by the way, it doesn't just apply to married people, it applies to intimate partners, is the wording, I think, in the statute, that if you're convicted of that, even a misdemeanor, you can't possess a gun. And of course, we've got a Second Amendment that says gun possession is allowed in the United States. And the definition, if you look at the federal statute, it looks like what Congress was looking at is when somebody gets assaulted or hurt in a domestic violence situation. But the wording is so vague that it looks like it could cover practically any kind of a touching between two partners. So a lot of the justices said, you know, this language is too vague and it's a real problem. What happens if a mother was washing out her son's tongue with soap to punish the use of profanity, which, by the way, maybe here in New York City, not too many people have heard of that punishment, but it's not so uncommon across the United States.
You wash your mouth out with soap?
Yeah, I think
I used to get threatened that, but I don't know if my mom ever did it.
Yeah, well,
could you go to jail now for doing it?
Well, I don't know. They might sentence you for 20 years in New York City, but you know, I think in a lot of places. And by the way, I saw my brother's mouth washed out with soap as well. You know, so and my mother never got arrested. But that in the modern age, in this age of you know, domestic violence legislation, child abuse legislation, that might be viewed as something that would be a domestic violence assault and would bar you from possession of a weapon. Now, did Congress intend that? I don't think so. I think Congress intended assaultive behavior, hurting somebody else.
Sure, because
that person shouldn't have a gun.
You could be arrested for domestic violence, as far as I guess maybe, I don't know if this is federal law or if it varies state to state, but for banging on the couch in an argument if the woman feels upset or threatened by that, or the man, whichever way it works, which is insane. But here's what Scalia said. He said, we sort of have two extreme positions. The government's arguing that the statute covers more touching, mere touching. That's one extreme. And you're arguing that the statute doesn't cover all bodily injury, but only what? Severe bodily injury? Why isn't there something in the middle? It doesn't cover touching, but it covers bodily injury. So maybe they'll come up with something in the middle. Who knows?
Well, yeah, they may come up with a compromise that says, you know, we're talking about assaults, and an assault has to involve, they may define the assault as something that involves physical injury as opposed to a mere touching, which technically could be an assault under law as it's traditionally defined.
All right, let's move on to this one. And this one, I think, took place on Wednesday. A majority of the justices here appeared to be skeptical, again, of a Massachusetts law that establishes a 35-foot buffer zone to prevent protesters from protesting outside clinics that perform abortions. And the protesters say this violates their First Amendment rights. And again, predicting is a fool's game, but if you listen to what they're writing about what the justices said and how they reacted, the justices appear to think that it might be a violation.
Well, yeah, and there's a real, you know, boy, I'll tell you, a lot of these arguments have been really interesting this week. The backstory on this is that there was a prior case called Hill versus Colorado, in which Colorado, and this is many years ago, Colorado enacted a statute that said you couldn't come within 100, if you were within 100 feet of a healthcare facility, you were not allowed to approach somebody who was going inside for an abortion. You couldn't come within 8 feet of them. And the Supreme Court upheld that. So you would think this case, they would uphold it. But, you know, the court has changed now. There are 4 clear-cut conservatives, 4 liberals, and 1 swing vote. So there's quite, you know, it's quite possible that this Massachusetts law will get thrown out. Because the court looks, when they're looking at free speech cases, they have a term, they call it strict scrutiny. I call it, you better have a real good reason if you're going to restrict free speech. And you better be able to show that you don't have a less restrictive alternative that would achieve the same purpose. Now, let me give you an example with respect to an abortion clinic. If you have a law that says you can't block access to an abortion clinic, that would be totally legal. But on the other hand, This law seeks to say that nobody can come within 35 feet of an abortion clinic and shout out or approach a woman who's going in for an abortion.
Yeah,
now,
why should that get special status?
Well, why should it? And that sounds like, and you also can't have a law that triggers and affects one kind of speech as opposed to another. It has to be content neutral.
Right.
This sounds like you're just going after abortion opponents and restricting their free speech. So I think the Hill versus Colorado ruling might in fact be overturned in this case, that this Massachusetts law just goes too far.
We have a lot of, like you said, very exciting cases if you're into this thing, and of course it affects how, to one extent or another, how we function as a society. All right, let me give you this, and this is just, to me, I just don't get it. The husband of the woman in Texas who's brain dead and is pregnant. The husband wants to pull the plug. The mother of the woman wants to pull the plug. They claim that she had expressed a wish that she never be hooked up to a machine. Of course, there's nothing in writing to that effect. It's just the word of the husband and the mother. And also, of course, they don't say that she said, hey, even if I'm pregnant, pull the plug. That I haven't heard that addressed by the husband or the mother. He's now gone to court. A judge has agreed to hear this. They want the plug pulled. But, as the weeks go by, the viability of this baby inside the mother who's brain dead becomes more and more. And I just can't fathom a grandmother and a prospective grandmother and a prospective father wanting to kill that baby, but they're going to court to try to do it.
Well, they are. And, I've got to say, when I look at this case, Steve, this is kind of one of those cases where conservative position and liberal positions, it's kind of hard to figure which side is which, because libertarians might say, for instance, it's none of the government's business. This is up to the family to decide whether to pull the plug or not. Liberals, on the other hand, usually find in favor of the government making the decision. And I think in this case, first of all, the mother is legally dead. She's been declared legally dead. So the question then becomes, does the fetus have any rights? Now, you have a living fetus inside this pregnant mother, but the fetus, as I understand it, is only about 14 weeks.
Well, it was 14 weeks at the beginning.
That's right.
Now it's well over 20.
Now it's over 20. If they say viability, they usually define that as occurring around 28 weeks, although we must say with modern technology, a lot of premature babies are born alive and develop normally.
Sure.
So is this fetus
legally
a person?
It a baby, but you could call it a fetus.
I'm trying to stay away from those terms because people define that different ways depending upon your religion.
Right.
But so the question to me is it a being who would be born alive, or that's what the court is struggling with. And this is not an easy issue in terms of the law. It may be in terms of religious belief, but the law is very tough in this area to fathom which way it will go.
Paul, fascinating conversation with 4 fascinating cases. Of course, even if the cases were boring, you would make it fascinating.
Thank you, Steve.
Paul Callan, ladies and gentlemen, CNN legal analyst, former New York City homicide prosecutor, and criminal defense attorney here on the Steve Malzberg Show. When we come back, want to send your kid to a Hamas summer camp to train them to be martyrs? It's going on in the Middle East, and these are the people Israel's supposed to sit down and give land to and make peace with. Haven't heard anything from Kerry on this, or Obama, or anybody, but we'll tell you about it. Steve Emerson will join us next hour, Ann Coulter and Congressman Peter King. Steve Malzberg Show, Newsmax TV and radio.